Before I call the next case on the docket, I wanted to announce that Justice Beyer is recused on this case, and she will be replaced also by Judge David Bruns of the Kansas Court of Appeals. While counsel still getting situated, I wanted to, on the record, publicly thank Judge Bruns on behalf of my colleagues for helping out the Supreme Court today. We appreciate it.
You're welcome.
Good.
May it please the Court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. Mr. Chief Justice, with the Court's permission, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Briefly, the background for the attorney discipline against the respondent in this case stems from his criminal conviction of 4 felonies in a Navy General Court-Martial. Following the findings of guilty of the court-martial and the approval of the case by the convening authority, notice was provided to this court, and this court on November 6, 2008, temporarily suspended the respondent in accordance with Supreme Court Rule 203. The 4 felonies, in essence, consisted of wrongful providing of classified information to unauthorized personnel. The sentence imposed by the court-martial was a dismissal and 6 months in confinement. The maximum sentence in the case was 13 years and a dismissal. Following the approval of the conviction by the convening authority, the respondent's case was appealed to the Navy Marine Court of Criminal Appeals, where it was fully briefed, and that court affirmed the findings and the sentence. Thereafter, the case was appealed to the United States Court of Criminal Appeals for the Armed Forces, where again the case was fully briefed, and the findings and the sentence were affirmed. That was the predicate for the panel hearing. At the panel hearing, the respondent was charged with violating 2 rules. And the rules were Kansas Rule of Professional Conduct 1.6a, which deals with breach of confidence of a client, and 8.4b, which is criminal conviction of a criminal offense, which adversely reflects on truth, honesty, and fitness as a lawyer. The respondent, while he did not contest the happenings of the court-martials or the findings of the court-martial, did contest that his conduct, as found, constituted violations of the KRPC, maintaining that he was faced with a choice of conscience between whether obeying the laws and the regulations and the duties of a commissioned officer as a judge advocate versus that of his interpretation of pronouncements by the United States Supreme Court in the case. All this dealt with his duties as a legal officer in the Joint Task Force Guantanamo, whereas this court was aware that there was a number of detainees, and there was a request by an outside source for the name of detainees who were not yet represented by counsel. And this was done in the spirit of the Supreme Court case. The respondent, on his own, went into a secret or secured computer, went into the database which contained secret classified information, printed off the material, and then for 13 days held the material, cut it up in strips, put it into a Valentine's card, and on the day he was departing Guantanamo back to the United States, he put it in the Valentine's and mailed it to this source in New York. did not sign the card, did not put a return address. That's the essence of the misconduct. He contended at the panel hearing that because of his duties as a lawyer to uphold the law and the pronouncement of the United States Supreme Court, that therefore his conduct was not adverse to his honesty or trustworthiness or fitness as a lawyer. The panel hearing, the panel did find violations of the two rules, and on review before this court, the respondent did not file exceptions to the findings of fact or the conclusions of law. At the panel hearing, I recommended that the appropriate discipline in the case was disbarment. The respondent argued that the appropriate disposition was he's already been punished enough and that he should just be allowed to return and practice law. The hearing panel recommended to this court that because of the prior temporary suspension, they recommended that there be a suspension, but that be retroactive to the temporary suspension, which means that he served all the time and then he should be immediately permitted to practice law. The basis for my recommendation for disbarment, which has not changed, and I renew that before this court, was I recommend that this court, as well as the panel, put themselves or play difference to the proceedings in the Navy General Court Martial, the Navy Convening Authority, and the two appellate courts. We're dealing here with a special setting surrounding the commission of the crimes. It is not like a non-military lawyer working for a company or working for a state agency revealing something confidential to an outside source. Rather, this is in a military setting in Guantanamo where there were the respondent, based on his experience and his training, knew that he was going into a classified computer. He was pooling up classified information. He had no authority. He did not, if he was faced with a moral dilemma of what to do, there was a number of avenues he could have pursued.
Excuse me, Counselor, are you saying that the culpability for disclosing or breaching client confidentiality is different depending on who the client is?
No.
So what difference does it make if you're a private lawyer working for a private employer and you breach the confidentiality of that employer? Why is that less culpable than if your employer happens to be United States military?
I view this as aggravating circumstances for the imposition of appropriate attorney discipline. And the setting here again is unique. I'm sorry, Your Honor, does that answer your question?
Yeah, thank you.
In the clandestine manner in which he committed the offenses, there is potential harm. The problem is the court-martial knew of the potential harm, the convening authority knew of the potential harm, the two appellate courts knew of the potential harm of his actions, but we do not know that potential harm. As referenced in the United States Court of Criminal Appeals, in footnote 4, there was a witness who was the intelligence officer for Guantanamo who testified for over 40 pages of testimony on this particular subject. The court makes comment to it, but it does not disclose what that testimony was. And these are the type of factors that weigh on the aggravating factors as to the significance of what's appropriate attorney discipline. Again, the respondent had a number of different avenues he could seek if he was faced with this moral ethical dilemma that he could have taken to get guidance. Rather, even though he knew about those avenues, he did not take advantage of them. I further believe that standard 4.41 is the appropriate ABA standard as to the 1.6 offense. The hearing panel found 4.22. The difference between the two is under 4.21, there's the added element that the information or the breach of confidence would go to a source which could benefit from this. Now, again, this is confidential information going out to us, an unauthorized individual to receive this, and they could have used it for the benefit or to another third party. For these reasons, I'm asking that this court affirm the findings, the conclusions of the hearing panel, but adopt the recommendation of disbarment as the appropriate discipline. If there's no further questions.
Do we have any questions of counsel? Thank you, counsel.
Thank you.
Please the court, I'm Jack Foch, and I'm proud to represent this respondent in this matter, and I would like to reserve 3 minutes for him to make his own statement at the court of the 15 minutes I get, which is not adequate in this case, but I'll try to do it. I've got to admit that, well, let's start with the beginning. Just a few weeks ago, you admitted a couple hundred new lawyers to the bar of this court. They took the same oath that you did and I did, and I want to look at that oath again with you for just a moment. It says, "You do solemnly swear or affirm that you will support and bear true allegiance to the Constitution of the United States and the Constitution of the State of Kansas, that you will neither delay nor deny the rights of any person through malice or lucre or from any unworthy desire." And I'll stop right there. That's the same oath we all took. The military take a little bit more of one where they say, in essence, that they will defend the Constitution against all enemies, foreign and domestic. And then I want to put that in the context of what this case is really all about. I note that counsel very carefully left out where it was that my client sent those addresses. We've never quarreled about what the facts are in this case, really. There's been no quarrel at all. He sent them to Barbara Olinsky, who was the deputy director of the Center for Constitutional Rights, who had written a letter to the Defense Department and the people down at Guantanamo demanding, in view of the 2 United States Supreme Court cases, Rasool and Hamid, that were decided the same day, that the detainees at Guantanamo were entitled to writs of habeas corpus, and they were entitled to counsel to represent them and assist them in that she was demanding the names and country of origin and the addresses of those people so they could contact their families to see whether or not they wanted to provide counsel or whether the Center for Constitutional Rights, which represented a number of Guantanamo detainees, could represent them. My client was aware that his client, the Defense Department, was going to stonewall that request. They were going to see what different reasons they could find to deny it. Put it in the context that it's really in, and this was kind of the defensive posture I took at the hearing. It is a violation of the Geneva Convention, Common Article 3, and the Constitution of the United States for any lawyer to assist his client in committing a criminal act, which is what that would have been under the Geneva Convention. The military people wanted to provide this. The Defense Department did not. And so they stalled, and as you heard, he got into the computer. He didn't know what all the stuff was. He got the names and addresses. What he got criticized for is there's some sort of alphanumeric code on there that if you had something to match up to it, you would apparently know, and we never have known what it was, you could apparently figure out who had interrogated them or something like that, but I don't know. What he did was he copied down, he got off the computer that list, he trimmed it up. Well, first of all, he put it in an office safe and waited for about 12 or 14 days. His time at the Guantanamo was coming to an end with the Joint Task Force, and he was going to leave. He knew he couldn't take it off base with him, but he was hoping that the government would change its position and give him those. But unfortunately, the same day that he sent them, January 14th, that he sent them, the government sent their letter to Mrs. Olansky saying, we've decided for the rights of the privacy of these Guantanamo detainees, we're not going to provide you this information. So he sent it. We have no quarrel with the fact that was a wrongful act. My point and purpose here today is to get you to do two things. One is to read the transcript of that hearing, because the hearing report, simply is kind of, as one of my friends described it one time, it's like a margarita without tequila. There is no flavor whatsoever to it, and in a couple of places, we didn't take any challenge with it, but in a couple of places it simply doesn't give you the picture. It really doesn't. For example, do you hear anything in that report about what witnesses were called? There were only two. There were two witnesses called, my client and Jeffrey Hazard, probably the leading expert on ethics in this country, who was, one of the exhibits, LL, is about that thick of his CV. He was the reporter for many of the ethics rules that we have. He was the author of The Law of Lawyering, which you all have cited. He came pro bono to testify, one, that my client, the respondent, was wrong. He should not have revealed it, but he was faced with a moral and a legal dilemma. What could he do when his client was not doing what they should do? And he said he took the wrong course. What he should have done was report up the ladder. He should have called somebody else, and he didn't do that. So he's wrong, and he should have been punished, and he was punished. And it was appropriate for him to be court-martialed. And he lost 20 years of benefits. He served 6 months in the brig. And then Jeffrey Hazard says, but the real question is, does that have anything to do with his fitness to practice law? No, I've looked at what he has done since. I've looked at the records, and the records here are much more eloquent than this report indicates. We ask that you just look at what one of his former commanding officers said. If I could serve, knowing what I know now, knowing about this, if I could serve with him again, I would, because he's an outstanding person. He's an outstanding naval officer. But he made a mistake. He got punished for it. It's proper. Mr. Hazard said it was proper for this court to suspend him when they did. But the fact is, he says enough is enough. When we developed those standards, we did it to protect the public, and the public doesn't need protection from this gentleman. All right, that's what my purpose is in part. To do that, to get you to read the transcript, and then to get to know Matt Diaz, because you'll only find that out as you read the transcript. And the transcript isn't very long. We only took 1 day to try that case. So this is this is the exhibit that is the CV of Mr. Hazard, and it's darn near as long as half of the transcript. But be that as it may, you got to know Matt Diaz and know where he was and who he was and how he came to this conclusion. He was assigned a spatial responsibility at Guantanamo for liaison with the civilian council who met with the government lawyers over the detainees there. Secondly, he was assigned the responsibility of investigating the Guantanamo detainees' criticism of abuse. He recognized that those detainees who had lawyers, the complaints diminished and disappeared, because they had somebody to represent him. he wanted the government to give this information up, but he took the wrong course. We're not saying, we've never said that it was right. What we tried to say was he had a legal and a moral dilemma. He had two duties and two oaths. One is he's going to protect and defend the Constitution of the United States. The Supreme Court has said these people are entitled to have habeas corpus. These people are entitled to have counsel. And his client was saying, we're going to stonewall them and we're not going to do that. The interesting thing is, when he was finally charged in the court-martial, it was after the Defense Department had finally lost the Freedom of Information Act and was required to give out, and did give out, the entire list of the detainees at Guantanamo. And you'll find that in one of those reports. I want to show you just one example of why I want you to read this. In the report, it says, on finding 45, on February 19th, the United States Navy Marine Corps Court of Criminal Appeals upheld his conviction. In doing so, they stated the appellate's argument that taking action for arguably pure and good motives excused his knowing violation of the law is nonsensical and dangerous. Then it goes on. Well, first of all, he didn't testify except after the finding, and then he testified in his own behalf on sentencing, and after the military court heard that, they sentenced him to 6 months. Secondly, that then went up on appeal, whether or not it was proper for them to leave out of the hearing his evidence of motive and why he acted as he did. And it's one of the exhibits in the case, the United States Court of Appeals for the Armed Forces, the final appeal court, said, appellate sought to argue that under the circumstances he was caught between what he reasonably believed to be conflicting duties. On the one hand, his duty as a naval officer and an officer of the court to uphold the Constitution and the rulings of the Supreme Court and the District Court in the habeas cases, and on the other hand, his duty as a naval officer to maintain the confidentiality of information that his superiors should have authorized for release but did not. Then the court goes ahead to say, the military judge concluded that none of the evidence proffered by appellant supported his argument that he was required to release classified information based on his duties as a commissioned officer. His ethical obligation as a judge, advocate, or his ethical obligation as a licensed attorney. The court goes ahead to say, appellate argues that his evidence would have supported what he viewed as a struggle between conflicting legal duties to the Constitution and the rulings of the Supreme Court on the one hand, and to maintain the confidentiality of information unauthorized for release on the other.
Excuse me,
such
counsel.
a context.
Counsel, are you still wishing for your client to address us?
Yeah, they were going to set it so that I only had 12 and they had 3.
All right.
I'm hoping that's what happened. Okay. In such a context, members might have found appellant's conduct foolish or inappropriate, given appellant's motives, not necessarily unbecoming or dishonorable. I'm going to just jump ahead a bit. In our view, appellant's general point is well-founded. Determination as to whether conduct charged under Article 133 is unbecoming an officer, and so forth. They found it was error, and then they used the customary good argument that, well, it was a harmless error.
How soon after this occurred did the government disclose the names that he disclosed?
They revealed the names, and I get that out of a footnote in one of them, in May of 2006.
And how
And
so
he
the
was
timeline
charged in 2007.
No, my question is when? So that was a year after.
Yeah.
He disclosed the names on Valentine's Day of what year?
Oh, 2005, I think.
So it was about 16 months later that the government
Finally got around to it. The pressure got to be too much, and they got around to it.
All right, thank you.
But the fact is that they weren't going to do it. And here he is as a lawyer with 2 oaths.
Counselor, as you were talking about the dilemma of divided loyalties, one as an attorney and one to the client, I had a flashback of a number of times in my practicing career when that conflict arose. It's not unique that you run into that circumstance. This
Right.
is of a higher purpose, perhaps, and maybe of a different degree, but I ran into that dilemma a lot of times, and I gave up a lot of fees because I had to withdraw from representation. And I guess I would ask you, because we think the purpose was more noble, that the consequence should be less?
No, I don't think necessarily so. If you look at some of the cases you have decided on these very grounds, suspension is appropriate, and that's what the three-pronged panel here were three former military men who understood this. One was our president of the Bar Association, Mr. Smithyman, forgotten who the panel chair was. I think you're good at
Warren
McCamish and Kenley Thompson were the three, and they were very cognizant of the fact. But if you read the transcript and read the arguments that were made to them, I tried to cite Mr. Walzak had said he was going to call Dean Romig in rebuttal and didn't, and I was so boned up for that because he had been very adamant about the government not doing some of the sort of things they were doing and forcing lawyers to do it, and he testified, and I had it all there and didn't get to use any of it. But I did get to, in argument, quote some of those things that were published about the special responsibilities that the government lawyers have. Now, what I'm saying is only by way of saying that the panel, if you read the whole transcript, the panel saw the witnesses, they heard the people, they knew what the standards were, and there was no finding ever made by anybody that this man is not fit or that he was dishonest. The only finding made by this panel was that it was not trustworthy what he did. We're saying very simply, we think you ought to uphold what the panel really carefully crafted in this position.
Do we have any further questions of counsel? I see none. Thank you, counsel. Would you like your client to address us?
Thank you. Good morning. May it please the court. Looking back at my actions in January 2005, as often as I have, I've come to realize that I was wrong for taking the actions that I did. It was foolish, criminal even, as you know. The writ of habeas throughout my life's experience had become important to me, and the Supreme Court had ordered or ruled that the detainees, those prisoners down at Guantanamo, were entitled to habeas. And as you heard, my client, my government, was preventing implementation of the District Court and Supreme Court's decisions on that matter. That, in conjunction with my investigations of the maltreatment of the prisoners there, motivated me to take the foolish criminal act that I did. No matter the circumstances, my obligation as an officer of the court is to alert my superiors of any wrongdoing that I observe and to comply with the rules of this court. I'm to leave any of this corrective action that I intended to impose to others that are way above my pay grade. And if they fail to take corrective action, I'm to find a way to honorably withdraw from the situation. I did not do that. I took the wrong course of action. I certainly should not have taken the law into my own hands. I can assure this court that I never will expect to be confronted with this type of situation again. Guantanamo is unique. My presence there was unique. I intend to practice law as a private citizen, not in the military. However, should such a situation present itself again, I know who to reach out to for guidance, people that are more experienced on these matters than I am. I know what I did was wrong, and I know I will never come close to doing anything like this again. I sincerely apologize to this court, to all my former colleagues, and particularly to Washburn University School of Law. Washburn gave me an opportunity that many other law schools did not, and I blew that awesome opportunity. Now, for the past 4 years, I've been working at the Bronx Defenders, a public defenders organization in New York City, doing non-lawyer work. I'm helping the most vulnerable among us, staying as close to the fight as I can get without actually practicing law. Last year, I passed the New York bar. I also passed another professional responsibility exam. And I hope to practice public interest law so that I can continue helping my fellow citizens. I hope this court can see the real Matt Diaz in your review of this case. And I hope you recognize that I have learned from my mistakes. And I hope most importantly, you see that I pose no threat to my future clients. I respectfully ask this court to adopt the panel's recommendation and allow me to get back to the profession I know and love. Thank you.
Counsel, before you sit down, are you currently licensed to practice law in any jurisdiction?
No, sir, only in Kansas, and I have yet to apply through New York, waiting on the disposition of this case before I actually apply for the character and fitness background check.
And has New York indicated that you need to get this issue resolved before they will look at your application?
That's one of the questions on the application, yes, sir, is what is the disposition of any prior disciplinary proceedings? So I'm waiting on the disposition so that I can answer that question.
And would you anticipate that all other jurisdictions like New York would take the same approach? They would be waiting to see what this court does?
Quite possibly. My understanding is New York wouldn't take their independent look at my character and fitness, but they still would like to know the disposition of this case.
Very good. Do we have any other questions? I see none. Thank you.
Thank you.
You've reserved 3 minutes for rebuttal.
3 quick points. One, you have to understand what level the respondent was on as a legal officer at Guantanamo. There was at least 4 levels, maybe 5 levels above him where he could have received help on this moral dilemma. At the panel hearing, I brought to the panel's attention the Kansas case of Crandon versus State, which is a 257, Kansas 727, which deals with the issue of a general counsel in a state agency faced with the need to report to an outside source. The second point is, in answer to one of the justice's questions, yes, approximately a little over a year after the offenses and after the court-martial of the respondent, after the offenses, the names of the detainees were released. However, what happened in this case was not just the names, but it was names and what's called interment series numbers. And those numbers, as the panel found and as recited in the various appellate court decisions, contain other information, and that information is still classified secret today. It's not out in the public. And my final point is the respondent's life experiences, his background, his military record, was fully considered by the convening authority and the court-martial at the time, and it was before the Navy Marine Corps of Criminal Appeals, and it's actually one of the assignment of errors as to whether or not the sentence is too severe. So it's been looked at.
But has it been looked at in terms of our decision? I don't hear any denial of a violation of the disciplinary rule. We're talking about disposition.
Correct.
And so he's admitted that he committed crimes and violated the 8.4B, but why wouldn't those other areas you just talked about, although it would not justify a criminal act, but would be applicable to our determination of an appropriate sanction?
I'm just trying to explain the significance of the treatment of all this material, that it just didn't pop up at the panel hearing, but it was considered by all different levels of the criminal proceedings, from the court-martial, action of the convening authority, and the two appellate courts.
Well, do you have a view about the need to protect the public? The argument on the other side was, hey, the public really doesn't need to be protected from this particular respondent because of the unique nature of the crime here. Do you have a response to that?
I do accept the respondent's statement that he would, faced with this again, he would not do it. I'm not sure if that answers your question. Your Honor.
It's fine.
Do we have any further questions of counsel? I see none. Thank you, counsel. I thank all of you for your comments this morning. Court will take this matter under advisement.